We're definitely in uncharted waters in terms of employers and employees in this COVID-19 pandemic. That would require a consensual agreement between the employer and the employee. So it's a possibility in terms of negotiated changes, but a unilateral change is not permissible. Persons are entitled to their benefits as a consequence of their contract, and the terms and conditions in that contract are negotiated in the first instance, and again we're back to any change being a consensual change. Well, again, that's going to depend on the arrangements within the pension trust, or it's going to depend on the basis on which the employer has subvented or is maybe entirely paying for the, for example, the health insurance for an employee. I think there's two things that we need to think about here. One can appreciate the pressure financially on organisations, but one also wants to bear in mind that this is something that will pass, and we're very conscious of looking to the durability of the employment relationship. So we're looking to keep a good employer-employee relationship. So it's certainly something that shouldn't be rushed into by an employer. I think this is a very real consideration for the circumstances that we're in at the moment. In the first instance, the employer should look to the remote working option. And clearly if somebody is providing their services per their contract of employment, then regular payment prevails in those circumstances. Should the remote working not be feasible for practical or security maybe reasons, then other options can be explored with the affected worker. That could include that they would take unpaid leave, that they may be paid now with an agreement to work up the time at a later stage, and clearly an agreement can be drawn up in that regard. There could be a facility for a working parent in those circumstances to take parental leave. Now, there's no payment that is made with parental leave. However, the individual continues to accrue their statutory rights in relation to annual leave, etc. So that may be an option that is more valuable to one person than another. And also, if the person involved is a new parent, the Parents' Leave Act, which would allow for a benefit payment to be made accordingly to that type of parent. In a circumstance where an individual is certified in terms of isolation, or indeed certified with the coronavirus, they are entitled in the current prevailing circumstances to apply for a particular illness benefit, which is in the amount of €305 that the state will make payable. Again, there may be a contractual entitlement via the employment contract for the individual, but at a minimum they would be entitled to this benefit in either of those circumstances. So whether they have been diagnosed or whether they've been asked to self-isolate by a medical practitioner. Unfortunately, again, there is no provision for payment because this doesn't fall into either category. It isn't a medical diagnosis nor a medical direction to self-isolate, nor is it a regular illness absence. So, in the realms of employment law, there is no provision for payment by either the state or an employer in those circumstances. Well, I think the first thing to say is we want to be empathetic as employers, and we can understand that this is a very anxious time for people. I think then, in order of a priority, the individual in the first instance needs to avail themselves of the update information via the HSE on COVID-19. And when they've done that, they can kind of signpost themselves a little bit better, but they also need to have a communication with their employer. And that would bring us back then to the range of options that are potentially there for the individual, perhaps to work from home or other arrangements be put in place. I suppose the worst set of circumstances would be where an individual would proceed without any engagement with their employer, and they would end up in a position where they'd be entitled to no financial support as a consequence of voluntary self-isolation. Force majeure has been a facility with us for an amount of time, and it has always been predicated on the requirement of the employee is necessitated by the urgent need of a family member, and this is due to illness or injury. So the family member, the degree of relationship would be a partner, a parent, a grandparent, or a sibling. And presently the leave entitlement, and it's paid leave, is 3 days in 1 year or 5 days in 3 years. And again, there's been some conversation in the Department of Employment and Social Protection, and the advices are that where this is something that is a requirement consequent on COVID, that employers would endeavour to provide the 5 days leave. Well, I think the short answer is no, and the reason behind that would be perhaps that it's impractical, or there may not be sufficient integrity in relation to data, and obviously there are stringent GDPR compliance issues around data, personal data and sensitive data. So for a host of reasons, it may not be an option for an employer to facilitate working from home. Where working from home is not an option, an employer may have to consider something like a layoff. Layoff is where an employer has not got sufficient work for an employee, nor do they envisage having work for that employee in the immediate future. There's a formality to the process of layoff, and the formality is essentially, firstly, the employer should have a term or condition in their contract that permits them to lay somebody off from their employment. And also there is a requirement for notice to be given to the individual who's going to be affected by layoff. Now, we are in unprecedented circumstances, and there is a view abroad that the COVID-19 pandemic, if you like, places an exceptional circumstance around the requirement around notice to be given to employees. So the reality is that employers should avail of an RP9 form, which is the formal notification form for commencing a layoff of a staff member. And we would also be advising, in ease of that situation, that they would be addressing the entitlement of an employee to access this emergency pandemic payment when they are laid off. The layoff, we can't say at the beginning of a layoff period how long it will last for, but in respect of layoff, the legislation provides that after 4 weeks of consecutive layoff, or 3 or more weeks over a 13-week period of layoff, that the affected worker is entitled to seek redundancy from their employer. So they would make an application for redundancy. Now, it's very important to state that if an employer foresees that they will be ultimately able to offer employment to that person who's laid off presently, they would issue a counter notice to that notice for redundancy. That has to be done within 7 days of the application being made for redundancy. So there are a few important timelines and formalities that employers have to be aware of. So in the first instance, issuing the RP9 form that is formally advising the individual that they are on layoff. The second element to consider is that the affected individual may signal their intent to seek redundancy. Where that is sought, and that can't be sought until at least 4 weeks of layoff have been endured, where that is requested, the employer may issue this counter notice within a 7-day period. And that's probably advisable given that because of the unique circumstances, it is very difficult for an organisation to gauge what the economy or the market for their product or service will be over the foreseeable couple of weeks. Another important consideration is that in the circumstance where the laid off worker applies for redundancy, that is deemed to be a voluntary application for redundancy, and so accordingly an employer would not be liable for minimum notice payments in those circumstances. This would be another, I suppose, response to diminishing requirements in an organisation. So this is where the individual in question is working half or less than half of the time that they would ordinarily be contracted to work, or they're receiving half or less than half of the wages that they would ordinarily be entitled to receive. Again, importantly, this is a formal process. It is the same RP9 form that is used, but the box that is ticked is that of short time, and with that then the affected worker can seek the benefit payment from the Department of Employment and Social Protection. Yes, I think the redundancy situation hopefully is one that we're not moving into quite immediately, but employers need to be aware of the parameters involved. So in the first instance, you have to have at least 104 weeks continuous service to qualify. You have to be a contract of service, so you have to be an employee. There are RSI contributions that have to have been made by the relevant employee. But really the driver around redundancy is that the position that the individual was occupying ceases to exist. So when the business gets to a position whereby it's not able to sustain itself at all, or whether it's not able to sustain a particular position, then a redundancy is the circumstance that applies to the worker. In the circumstance of a statutory redundancy, presuming somebody is qualified, they must be over 16 years of age in order to do so, as well as having the 2 years continuous service. The statutory amount is €600 as the weekly amount, and the calculation is done on the basis of 2 weeks for every year's service plus 1 bonus week. And this is not a taxable amount. Well, I think the first thing is to focus on the relationship and to try and sustain the relationship through this pandemic. That would require the employer to review the prospects of remote working, working from home, or other alternatives, keeping the employment relationship intact. Where that is not possible because of trading or economic circumstances, then the employer will have to look at perhaps reducing the working week, and that would be a short time provision or a temporary layoff circumstance. With the employee not being able to come into the workplace for reasons of their own health, or indeed a close family member's health, and they've had to self-isolate, it's very important that the employer provide all of the up-to-date information, both from an employer perspective but also from a public health perspective. We will get through this pandemic, and what we want is we want a sustainable work relationship at the far end of it. So clarity of communication, responsibility in-house in terms of the organisation as to who is going to deliver the updated messages to the workforce, whether they are on site working remotely or indeed on short time or temporary layoff, and being as upfront with the workforce in terms of decisions that the organisation will have to take into the future.